Great. Well, it looks like some of the attendees who are coming in, it's kind of slowing down. So we're going to go ahead and get started. Thank you to everybody who's joining us tonight from all over the U.S. Thank you especially to our speakers who are joining us tonight from Dallas, Texas. I have the pleasure of introducing Rwan Hardesty and Jason Larman. And you'll have to pardon me, Jason, if I mess up your last name.
That's okay.
So both Rwan and Jason graduated from SMU Dedman School of Law here in Dallas. I've known Rwan for years. We've worked on a number of appeals together. She started her career doing civil work, including collections, subrogation, and insurance, and then began taking on appellate work, a bit like myself, including defamation cases and later in the family law realm. So she started her own law firm in 2014, focused on appeals and family law. And essentially now most of her practice is focused on family law appeals with her law firm, family and appellate law. Jason, he began his career as an appellate prosecutor, where he became board certified in criminal appellate law. So we have a wealth of appellate knowledge here as well. After leaving his position as a prosecutor, he began working with Rwan's firm, helping with error preservation, trial strategy, research, appellate briefing, and taking on criminal appeals. And he's now stepped up to the position of partner and heads up the criminal appellate and error preservation division of the law firm. So both Rwan and Jason have started a new podcast called The Appeal of It. I would highly recommend that everybody follow it. So tonight, we're going to have, this is a very big topic, lots to discuss. So I'm going to let Rwan and Jason take over. The two of them will be speaking to you all tonight. We are going to set aside 5 to 10 minutes for a Q&A session at the end. If you would like to, feel free, for those attending, feel free to post questions in the comments or in the, we'll have a Q&A chat going. If you'd like to post there, and they'll either be addressed throughout the session if the question is relevant, or they'll be saved until the end of it. So with that, I will turn it over to you, Rwan and Jason.
Great. Thank you so much for the introduction, Lindsey. And in fact, really quickly, Lindsey's the first attorney that helped me with my first appeal. So it was really informative at that time. She helped me out a whole lot. But today we're talking about artificial intelligence and whether we can use it, should we use it? And y'all will probably see a couple of dogs, maybe 3 dogs wandering around, and one of them has a cone on her head. If you see that over here. So just be aware. So Jason and I wanted to talk about this topic because it is super important. We've had a few issues come up this year alone where, at least in one instance, some attorneys in New York got sanctioned for the use of ChatGPT. And we wanted to start there and talk to you about this decision and kind of what happened. Initially, we had a couple of attorneys that had a brief due. I believe it was just a trial brief or a hearing brief for the court. It was in the U.S. District Court up in New York. And shortly after that brief was turned in, we had opposing counsel say, hey, there are some citations in here that aren't correct. We don't know what they are. Can somebody kind of alert us of where they came from? And the attorneys that wrote the brief basically said, oh, no, those are correct cites. This is what they say. And, we don't have any issues with these. Eventually it comes out, and I'm sure everybody's heard what happened. Eventually it comes out that these attorneys had used ChatGPT. They were on a very short deadline. And instead of using Westlaw or LexisNexis or any other search engine that would have been more legal savvy or normal legal research, they doubled down and said these cases are true, and they eventually said we use this ChatGPT, and these cases say these things. The court basically got very mad at them. He said ultimately that these fake citations shouldn't have been had. They should have basically found them. And so he ends up fining them $5,000. So we kind of start with them because we talk a little bit about why, we want to know whether or not we should use these programs. And so after this happens, we find out that the attorneys said, well, we were duped by ChatGPT. We thought it was giving us real sites. We thought these were real cases. And the court basically ultimately said, had you all told us at the beginning that these were illegitimate citations, the result of my sanctions on you would have been different. Now, on top of the sanction of the monetary sanction, the judge also told them that they had to go and tell every single judge that was listed as the author of those fake cases that they were listed in these fake cases. The other big thing that happened this year was, and Jason alerted me of this, was there was a company that ended up putting together an AI for court cases. And they named themselves Do Not Pay, and it was for traffic tickets. They wanted to go in and basically be in the ear of a defendant and tell them what they should say to a court while they're actually standing there real time. So on January 20th, the CEO, he tweeted out and he said, hey, on February 22nd at 1:30 p.m., history is going to be made. For the first time ever, a robot is going to represent someone in a US courtroom. I'm sure a lot of us heard about this in the news stories. And basically what they were going to do was have this AI on a phone in somebody's ear, listening to what was occurring in court and telling that person what to say while they were in the ear. So after that was tweeted out, the state bar of whatever state it was at, they never really tell us where it was at, tells the CEO, if you go through with this, we will fine you and we will put you in jail, or we'll figure out how to put you in jail. So 5 days later, on January 25th, he tweets out again, I'm going to be postponing this. We're not going to do this. I don't want to be put in jail. So that's kind of where we start. That's why this has become a big deal. So let me kind of turn it over to Jason, whose name is also Rwan on his screen still. And I think he wanted to talk a little bit about where we find these search engines.
Yeah. So what I think a lot of people are aware of is these services exist, right? We've all seen the headlines and everything else, but I think a lot of people have never used them, or they've never tried to use them, and they don't know where to find them. So very recently, probably in the last week or two, I've noticed that Google has started to include it sort of at the top of their search page. So you may have seen sort of a different colored box with sort of more conversational results on your Google search. There are some other options out there. There are some private services out there. If you just want to kind of play with it, Microsoft has partnered with the OpenAI that sort of created the ChatGPT stuff. So you can just go to like the Bing app and you can actually get into a chat program that way. That, for obviously the people that are sort of unfamiliar with it, that just want to kind of see what these are and kind of see what they can do, that's probably the easiest way to get to it, is through sort of the Bing partnership there. As strange as it feels to recommend Bing as a search engine, it is a good way to get into it. A couple of sort of tips to get you started if you decide to go play with it. You know, it will tell you a lot of information. You can ask it just about anything and it'll pretty much answer anything you ask. you can put sort of prompts in your questions that will help sort of change the tone of it. So, you know, you can put in there, hey, I'm researching for, you know, a topic related to my PhD, or you can tell it to assume that I'm a lawyer, or you can tell it to assume that it's a legal brief or whatever, and it will actually, surprisingly enough, it'll change some of the tone of the way that it talks. And we'll get into more after we kind of get through some of the ethical stuff on sort of the pitfalls and some of that. But if you just want to get on and just want to play with it, Bing is probably the simplest way to get to it. And again, you can just sort of type your prompts in there and you'll just get a whole bunch of information back. So Rwan?
Yeah, so so I saw a question, and for that question that's been asked, we will answer it as we kind of go through. And Lindsey, is it okay if we talk about the specific engines that are out there that are AI, like their names?
Absolutely.
Okay. So obviously we've talked about ChatGPT. That's been used. That's been the most widely known across all of the news outlets. People have talked about it in various ways. I've seen it talked about on various Facebook groups, lawyer Facebook groups, etc. You know, because there are a lot of people that are trying to figure out how to use it and why to use it. But there's a couple others that have come out. Jason alluded to the one that's on Google, and I think it's called Google Bard. I did not have a chance to play with it today. We actually had a brief due last night at midnight, so we've been working nonstop on that. And then there's another one that doesn't appear to have come out completely yet, but another, we believe a law firm or some sort of security firm or both have partnered with Harvey AI, and that one looks like it's going to be an actual legal search engine AI type of program. And what I kind of envision that it's going to look like is Westlaw that has been generated by an AI program. So what I noticed when I was researching a couple of these is specifically with the ChatGPT one, I couldn't get into the Google Bard terms and services as well as I wanted to, but I was able to get into the ChatGPT one. And in their FAQ, they're very particular in saying that, you know, they say, as a part of our commitment to a safe and responsible AI, we review conversations to improve our systems and to ensure the content complies with our policies and safety requirements. So what they're essentially saying is that actual people are reviewing the prompts that are being put into the AI search engine. On top of that, they say in their FAQ, we are not able to delete specific prompts from your history, so please don't share any sensitive information in your conversations. So obviously that brings us to a couple of our legal ethical duties. And I believe that that's what the question that popped up was about, is how is this not going to breach our duties? Well, it will if we're not being very careful. So if the information that we put in is not confidential and we have a duty of confidentiality with our clients, we definitely shouldn't be using prompts that could, you know, tell the world who our client is or any of their confidential information. So the three big things that kind of popped up in my head while I was reviewing these is that we have our legal duties. And with regard to the AI programs, we have to deal with or worry about our duty of competence, our duty of our candor with the tribunal, and then our duty, like I said, to maintain our client confidences. So I went to the ABA because obviously we're not all practicing in the same jurisdictions. We're not going to law school in the same jurisdictions. And the ABA is very specific, and they say, you know, with regard to confidentiality, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, and we have to make sure that we make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of our clients. So, if these attorneys in New York had entered in their clients' names to generate their briefing, they've already blown their duty to maintain their client confidences at that moment. So any information that they were trying to gather or research, they've completely blown that issue. In New York, they have their own very similar rules, and I have them, but I don't think that they're necessary for us to go into. So then we have the duty of competence, which is a huge deal, especially now with a lot of attorneys getting older. And I was just, joking with Jason, we're in our 40s already, which isn't that old, hopefully. I'm struggling to keep up with some of the technological advances that are happening because I simply don't use a lot of them. I've got young kids, and so, they may be using Snapchat. I don't use it. So that's like technology that I'm not used to. And as we have a duty of competence, not only are we supposed to have, according to the ABA and almost all of the rules of professional conduct across the United States, we're supposed to ensure that we have the legal knowledge, we have the legal skill, we're thorough, we're prepared, all of that for our clients. But also, we have to maintain our skill level with regard to technology and relevant technology. So, when Jason and I believe when Lindsey was still in school, when we were doing legal research, we literally started with the books, and then we flipped over to Westlaw and Lexis because that's what was coming up in the next generation of lawyers. So we very quickly discarded the books. I mean, if you asked me to go pick up a reporter, I wouldn't know what to do with it anymore. But now we also have to worry about all of these AI programs on top of Westlaw, on top of Lexis, on top of Fastcase, as well as all of our word processing services, and all of that. And as a business owner, my technology also includes things as simple as my phone lines and, my billing software and things like that. So that's our competency piece. And then finally, we have the duty of candor to the courts. And essentially, we aren't allowed to knowingly make false statements of fact or law to the courts, especially if they're a material fact. So that at its base makes, a lot of lawyers really uncomfortable because there are times when we're kind of skirting the line as to what a piece of law may say because the law is gray. So the issue with ChatGPT or any of these AI generated programs is, what if we don't know what that law is? So I'll go ahead and turn it to Jason and see if he has any solutions.
Yeah. So, there's a few different aspects to this. One is, I guess in a way, treat it like sort of a first-year associate or maybe a third-year law student, in the sense that it may bring you something that looks great, but it might not be accurate. One of the things you see a lot in the literature is sort of this concept of hallucinations. And that's essentially where the program will fabricate information where it can't find what it's looking for. In sort of preparing for this, I started just sort of hammering a bunch of different questions at it, sort of both in the context of things that I was familiar with and things that I wasn't. And I found some limitations with it. So a couple of examples, Texas recently, in this past legislature, passed a law outlawing motorcycles from lane splitting. There was new information, and I was just curious, hey, what's it going to say if I ask it if lane splitting is legal in Texas? And what I got was a perfectly valid answer for before the law had changed, and it sounded great. But that's one of the limitations of it, is it's not going to acknowledge things like, hey, my sources might be outdated. To sort of put a more dangerous point on it, I had also asked it about the mistake of fact defense in Texas. And those that are familiar with the mistake of fact defense, it's essentially that if the facts as you believed them to be true were in fact true, and that would change your culpability for an offense, then you're not responsible for the conduct. So it's the scenario where you're carrying a bag of flour out of the grocery store and the DEA arrests you because it was really cocaine. If you believed it to be flour, then you're not. But there are certain instances where it's not. And, today, one of the prompts that came back on mistake of fact had 3 cases, and it sort of addressed accurately the nuances in the first 2 cases. And then, somewhat alarmingly, it invented from whole cloth the 3rd case. And the conclusion that it drew from the 3rd case, which did not exist, was the opposite of the law. So, one of my mentors years ago, who's an avid newspaper reader, used to talk about this sort of phenomenon where everybody sort of believes that everything in the newspaper is true, except for that one story that they have personal knowledge about. And I think that these run the real risk of sort of coming into that, because we all know that outside our expertise, we're not going to spot areas where we just don't have the information. So, you can very easily use these as sort of a tool to sort of get sort of Wikipedia level knowledge very quickly. You can use them to draft even language for things that you're working on. But it's very easy to fall into the trap of trusting them to do things that they shouldn't be doing. And that's one of the risks there. But I think at the other end of the spectrum, and Rwan kind of hinted at this earlier, we do have sort of an obligation to keep up with some of this technology. It wouldn't work to start, preparing all your legal documents on typewriter and then billing your clients by the hour to go back and retype them every time you find an error. And I think we will see that become a part of what we're doing here, where the time savings from these will sometimes require us to really pay attention to kind of how things are going. Rwan, did you want to add to that?
Just when we are talking about using these generators, what I've seen a lot of attorneys that are trying it out do is, hey, I need to write something, or write a letter, or write a my favorite example, and kind of, I haven't done this yet, but there are many times when we're practicing law when we have either a client or an opposing counsel that gets us a little riled up. They've sent us an email, they've sent us or they've called us and left us a voicemail that is unpleasant at best, and we have to respond. Now, the old way was always, if you're going to write an email, obviously let it sit, read it again, rewrite it if you need to, but don't just shoot off an email because you want to write everything as if it's going to be shown in court. But I've heard and seen some attorneys have success in using the AI generated model, or even ChatGPT or some other program, in recrafting their emails or their letters or whatever it may be, to tone them down and to make them more palatable, but still say kind of the same thing. Now, what's funny is I practice in family law, primarily family law appeals, and I do trial work in family law. And I'm sure everybody has heard that, or not everybody, but you will learn that there is a program out there called Our Family Wizard. And it's basically a messaging app for the parents so that they can talk to each other in, it's basically like an email format. And the calendar there, my dogs heard something outside. They have a calendar there, and then, they take care of all their needs in that program, financial, etc. So one of the things in there is, as somebody is typing, it has a little bit of that AI in it, in that if they're using words that are excessively long or mean, or they're typing very quickly or something like that, it rates the level of their, I guess, their communication as to whether it's, needs to be toned down, or if they're starting to get riled up or something to that effect. And it'll alert them and say, hey, maybe you should tone it down, or something to that effect. So, that's kind of a good way, I think, that we can try and use these programs. And the issues that we have kind of talked about are issues that we've always had. So even in that brief that I was talking about, Jason and I were working on it yesterday late into the evening. And at, I think, 4 o'clock, he's editing a section that I had written, and he says to me, hasn't this been overruled by statute? And I was like, I don't know. I've been writing for 3 days straight. If it has, let's find out. And this is us using Westlaw and all of the tools that are legitimate legal tools. And so we had to go back and kind of not really fully redraft, but just revise the fact that I had used pre-statute law, because, here in Texas, we're changing statutes every 2 years sometimes. So, we can have case law that's from 2013, and we've had a statutory change in 2015, and we didn't realize it until we get in there. So, even using our Westlaw, even using our best practices, we're still making these mistakes because we're human. So, we want to make sure that the practices that we put in place as law students and lawyers, if we're going to continue on and start into this other technology, that we're going back and checking our work consistently. And we're not thankfully we found it at 4 or 5 o'clock and not at 11:50 when, the brief was basically due 9 minutes later. And so that's kind of where we want to talk about, is it okay to use these programs? And I think ultimately the answer will be yes, so long as we are looking at other avenues to make sure that we are, fulfilling all of our legal duties. Is that kind of where you wanted to go, Jason, with that, or?
Yes.
Okay. Do you have anything more, or should I keep going?
You can keep going.
Okay. So, when those attorneys, I kind of want to take it back to the New York attorneys, when they were actually talking, I think what ends up being said by one of the attorneys, let's see, I actually put a couple of the things that they said. One of the attorneys said that they were duped by ChatGPT and didn't believe it would make up cases out of whole cloth. I mean, the problem with that is the attorney that actually was doing the research, had found out about it from his college-aged kids. So he's probably a little older than we are. And he learned about it from articles, and he just believed that it was this super engine that was better than Google and Westlaw and, all of the things that we've already used. And so he just kind of went with it. He didn't know anything about ChatGPT when he used it. He just went in and just said, okay, let's see what it does, and then took it to the court. So the other problem was that the attorney that signed the brief didn't read the brief or do any of the research. Now, last night, after we were done with the brief, I asked Jason, I said, so what do you think of the brief? It's my brief. So he was helping me edit it. And his response to me was, well, if anything's wrong in it, I'm pointing to you because you wrote it, which is true, right? So if I'm the one that writes it, I should be the one that takes responsibility for what's in there. If I'm the one that researched it, I'm the one that takes responsibility for what's on there. Even though Jason's name is also on the brief, I'm the lead attorney on that brief. So here with the New York attorneys, the person that signed the brief didn't write the brief, didn't research the brief, didn't read the brief. He just signed it and then turned it in. And the other attorney that did all of the research and the writing and all of that, his name wasn't even on the brief. So that's a problem in and of itself. You can't do that at all. You know, you should be reading everything that you put your name on, because that's your law license on the line. The other things that were said after the judge was about ready to sanction them, the attorney that didn't write the brief wrote a, I guess, an affidavit to the court, basically saying that he didn't do these things, I guess trying to absolve himself of his responsibility. And ultimately the court ends up saying specifically, you know, if the matter had ended, this is the court actually talking, in his opinion, he said that if the matter had ended with respondents coming clean about their actions shortly after they received the defendant's March 15th brief questioning the existence of the cases, or after they reviewed the court's orders in April requiring production of the cases, my decision would have been different. I may not have sanctioned them because they took responsibility. And here he says, instead, they doubled down and did not begin to dribble out the truth until well after May. Now, remember, they wrote this in March, I believe, earlier than March. And, you know, it wasn't until I had to issue an order to show cause as to why they should not be sanctioned for their work. So, you know, ultimately, I think that these cases are really showing us where we as lawyers just need to be very diligent when we're working through all of these technology issues. Here in Texas, we ended up having one of our district judges, one of our federal district judges, you know, glom on to this issue. And he now, if you're practicing in front of this specific judge, you have to certify in your pleadings that you have not used a artificial intelligence generated, you know, work product, or let's see what exactly it says is, or any language. You have to say no language has been drafted by technology, but if it has, that it was checked for accuracy by a human being. And so for those of you that haven't practiced law yet, I believe there's a few law students in here, many law students in here. You know, as a officer of the court, you can just sign a certificate of conference. You know, at the end of your pleadings, you'll usually have a certificate of service saying, hey, I served all of these people these documents, they got the money. Sometimes you have to do something called a certificate of conference, where you're telling them that I talked to them about the substantive issues in this document. And now this specific judge is also saying, you have to certify to me that you have not, you know, run afoul of these rules. So I guess if Jason wanted to talk quickly about, you know, any like specific things that you thought were interesting when you were playing with them.
I think what you were just touching on, I mean, I think that sort of brings up sort of one of the more important issues here, and that is, you know, this is different technology. You know, everything else prior to this, you know, the move from books to Westlaw to sort of the more advanced Westlaw tools to, you know, typewriter to word processing, all of those were specifically to make the work we were doing more efficient. And I think where this is different and where there's more pitfalls to it is this will make work out of nothing. So if you find a case on Westlaw, your only real responsibility is to make sure that it does say what you need it to say before you rely on it. You know, if you find things on Google, you know, it's subject to the reliability of those sources, but ultimately those sources are themselves real. And I think, I mean, I know I kind of already touched on the hallucinations thing, but I think a lot of people underestimate just how real of an issue that is for these programs at the stage that they're at right now. So, I mean, I think there's a pending lawsuit in Australia where it basically accused a politician of corruption, when in reality, it just mixed up some of the facts. We've got sort of those made up cases. I've had it make up sort of false sources, like we talked about before. That's something that's very different about the technology. And so as we move to implement it, as we move to take advantage of the time-saving resources that it has, we need to view it differently so that we can sort of be alert to the fact that it really will just make things up. That's not something that's been an issue before. Microsoft Word doesn't create, new things and just toss them in there. This will create information, and some of that information will be reliable, and some of that information will save you time, but some of that information will be fictional. And I think it's important, again, to just kind of stress just how frequent of an issue that is, because it's very good at aggregating information, but where it isn't great is sort of the ethical constraints that the rest of us try to follow. So when you are using these things, it really is important that you are, in essence, supervising it. Treat it like you're reviewing, something from opposing counsel or whatever, where you're looking for the holes in it, looking for the inaccuracies. But I think the next point, and where I think we kind of want to end as we get closer to sort of running out of time here, is where's this headed, right? Where's the future of this? Because I think what we can all acknowledge is that technology is not going to stop moving. So there are services out there right now that are marketing, basically a chat service that you can put on your website, and it'll handle sort of those superficial inquiries from a client and sort of feed into that sort of generation funnel without having to necessarily tie up a human being. And there are services that are either launching or soon to launch that are going to be, legal research focused. And those are going to be, an effort to use this technology to sort of apply it in the very narrow areas where it might be beneficial to a lawyer. So as you see that happening, we're all sort of spectators to it right now. As we see that happening, I think at some point the question becomes, when is it too late to try and get on board? And I don't think it's at the point where you necessarily have to be using these services now, but I think that maybe the next generation of them, or the generation after that, they will have gotten some of these sort of pitfalls and some of these hazards worked out on them, where, it may be necessary for some of us aging lawyers to try and sort of bring that into our practice as a way to just sort of fairly charge our clients for our time. There's sort of an additional ethical component there of, we can't ethically charge a client for wasting their time. And so if there's a time-saving tool out there, whether it be a word processor or a Westlaw subscription or anything else, we do have some obligation to take advantage of those things.
So I wanted to, just quickly read what Judge Starr out here in Texas did say, and it kind of goes with this ethical obligation. It says, or he specifically wrote, while attorneys swear an oath to set aside their personal prejudice, biases, and beliefs to faithfully uphold the law and represent their clients, Generative artificial intelligence is the product of programming devised by humans who did not have to swear such an oath. As such, these systems hold no allegiance to any client, the rule of law, or the laws and Constitution of the United States, or as addressed above, the truth. And so, and when it's making up cases, it has no reason whatsoever to tell you that it's fake. It's, you've asked it a question, it's going to give you an answer. And Jason, what did it ever say? I don't know when you asked it a question that you can remember?
I've never gotten an I don't know. Like I said, I've sort of hammered it with a bunch of different questions. I had it do everything from, basically I think I had it write a motion to suppress. And, it was probably better than some of the lawyers I've seen, but there were parts of it that definitely were incorrect. And I think at one point I asked it to write a chapter to a book, and I gave it, 4 points to include in the chapter, wrote a chapter to a book with dialogue and everything else. It will tell you something pretty much regardless of what you ask it. And again, I would say the overwhelming majority of the information that came back was accurate. At least in the areas where I knew whether it was accurate or not. And I don't know about the areas that were sort of outside my expertise. So it'll always give you an answer. And, they'll throw a disclaimer on it that says, this may be fact specific. You should probably consult a lawyer. Isn't particularly helpful if you are a lawyer, things like that. But it will just tell you something every time. So, and not to disparage some of our younger lawyers in the population or that are listening to us, but it's a lot like dealing with a lawyer that just doesn't have much experience. And, we've all dealt with those lawyers that will answer a question with something, even if they don't necessarily know the answer. And it's very easy to spot when they get off track in an area that we're familiar with. But some of them make it sound pretty convincing. And this kind of has the same pitfalls. It doesn't really know as much as it sort of presents itself as. So I guess to kind of recap some of the concerns there, the first is these are not confidential. These are being, if nothing else, fed into the machine for the next person that asks. So any information you put in there, you need to be aware is not confidential. The second is duty of competence and supervision you're producing, for whatever means, is accurate to the best of our abilities. And then the third, and sort of connected to that, is we just cannot trust at this point with the technology that's out there that everything it tells us will be true. And to give you an example of that, the reporting on ChatGPT, the version that's out there right now, is that the training that they did on that model was based on information that ended in September of 2021. Or I think it was September 2021. It was the year 2021, meaning any new information, any new facts, any new historical events or anything else that has happened since then, it's simply unaware of. So recognize these for the limitations that they have if you're going to start to rely on them. But also, and we talked about this before, I think we're on sort of a path where these are going to be services that lawyers need to start paying attention to, because they are going to hit the point where there's time savings, there's efficiencies, and there's just sort of a shift. And it would surprise me if companies like Westlaw and Lexis and those kind of things are not actively developing their own tools to implement this so that their search capabilities become more efficient, just like these services that are just out on the open web.
All right. So did we want to just go ahead and answer the questions that are in our little chat over here? I think they're great questions. So should I read it, Lindsay, and then
Sure.
kind of answer?
Yeah,
it?
sure.
Okay.
That'd be great.
All right. So the first person, it was an anonymous attendee, and she said, or she or he said, I'm still figuring this out as a law student, but how is this not an illegal practice of law, plagiarism, to use ChatGPT to write briefs? I can understand using AI for things like spelling and grammar software, but it doesn't seem like something to use for substantial law-related work other than demand letters or something simple. So I know in law school you aren't allowed to plagiarize. In the real legal world, you are trying not to spend your client's money. And so just as don't do this in law school because you're not allowed to, but once you get out, you're going to use other people's briefs as your base, where you start. And then you're going to edit them off of there. You don't want to reinvent the wheel. So plagiarism isn't as scary of a thing out in the real world in the legal sense. Because you're really not plagiarizing, you're just trying to
you're sharing work.
You're sharing work. And all the lawyers know it.
You're also looking at what has been successful in the past. If certain arguments have been successful to the court in which you're producing a brief or you're doing oral argument, by all means,
right.
You want to look at what's been successful.
Absolutely. And there are many times where I know that there's been an attorney that has written a brief on a specific issue that I say, hey, can I have your Word document, or can I see it just so that I am not starting all the way over? Can you send me something? Because a lot of times we can't pull the briefs. You guys, as students, you get unlimited Westlaw. As lawyers, we're not paying for the briefs. They're expensive. And so you have to actually go to the source and ask them for it. So as far as it not being an illegal practice of law, it's not. What it really comes down to is making sure that as the lawyer, you are taking the appropriate steps to make sure that what you're putting out there is the law and what is the correct law, and fulfilling all of your ethical obligations with regard to that. Definitely, I would use it for spelling, grammar, things like that. That's a great use for them right now, drafting the demand letters, drafting other letters to clients, and maybe even some, just baseline, I just need a shell of something just to start. There are many times that I start something and I'm like, I have writer's block and there's nothing I can do about it. So this might be a good way to kind of jumpstart that. Anything else on that question, Jason?
Well, the very tail end of that question is whether it's really something to use for substantial law-related work or other demand letters. And demand letters is something simple. My impression of it, having spent, I guess, a decent amount of time with it, is it's probably more in the latter category right now. My sense was that it's a lot like the way I might use Wikipedia to learn about a topic, in the sense that it's a quick, fairly reliable source of information, but not one that I would ever want as my primary source. So it's a great way to just get sort of that superficial knowledge, to get sort of the surface level, and even maybe a few layers beneath that very, very quickly, far quicker than you could do a Google search and poke through a couple of pages of results or anything like that. It'll just come back in 30 seconds to a minute with a very lengthy and a very thorough answer, which again, as sort of a secondary source, can be very, very useful. In terms of putting together documentation and things like that, I'm not at a point where I would trust it to write a brief, but I would not hesitate to at least let it draft sort of a framework to build something like a demand letter or things like that. Our next question: has malpractice insurance caught up with AI-related liability yet? Says, for example, ChatGPT's user agreement has an indemnity clause. If you and ChatGPT are sued by a client for using AI, has there been any indication insurance will cover or not?
I haven't looked into that, to be
I-
honest.
Yeah, having done quite a few legal malpractice cases, I'm not sure the technology has caught up to the case law or to the precedent that we would be seeing yet. If that's taking place, it's probably in its infant stages with demand letters, maybe some pre-suit negotiation. But for the most part, what I'm seeing is that there is still an emphasis on legal malpractice. It's a tort. It's a duty. And are us as lawyers breaching that duty? So what is our duty to clients with respect to ChatGPT? And that's a very gray area right now. It's how much do we need to know this technology if we're going to use it? What are our obligations of how much to be familiar? And then ultimately, however much us as lawyers are using and relying on GPT, how much does our reliance on that or other AI actually cause our clients harm? But that's getting way into the weeds of of legal malpractice cases. But I haven't seen anything specific come through down through the pipes yet on that. I'm sure it will. I'm sure it will sooner rather than later.
Right, absolutely.
There's at least a lawyer in New York who probably got a call from his insurance company about it.
Oh yeah.
Yeah. The next question is, how can an honest attorney claim that a certain case says something specific without ever reading the case, or is that the answer? So just very quickly, I've worked at firms that are large and technically I'm solo, even though Jason is with me now as a partner. I've been solo. I've had multiple attorneys. Typically an attorney, as long as there's another attorney kind of reviewing it. So a lot of times, you'll have a partner, have an associate brief something, read a piece of law and tell you what it says. A lot of times you'll send an associate a message that says, I need law that says this, and they have to go find it for you wherever it may be. So technically some attorneys are not reading all of their cases, and that's okay so long as it has been vetted and that it is good law. Now, if you're solo or you're not relying on associates, because they also have their own, malpractice insurance, they've got their own licenses. So hopefully they're fulfilling their obligations as officers of the court. But, as a solo or as a two partner firm with no associates, we're doing our own work. So we are reading every single case and making sure that it is good and what it says. And I would never go in front of a judge without knowing what a specific case would say and knowing what the other side's argument will be and how it would be distinguished. Because I've gone to court many times where an attorney will say this case stands for this proposition. And, I'll be reading the case and I'll be like, I didn't pull that case when I was preparing for this matter, and I should have, if that's what that stands for. And I'll read it and I'll be like, no, it doesn't. The facts don't line up. This is completely distinguishable on various things. And then sometimes if I'm able to pull my phone out and actually check the law, sometimes it's not good law anymore, and it's got negative treatment all over the place. So I guess the answer is that you should be reading the law. That's your job. You should be reading those cases because that's your job. So anything else that you want to add to that?
I mean, yeah, I think that's true. Regardless of who brings you a case or sort of how it comes into your hands, somebody with sort of an obligation to get it right needs to be reviewing it. I would be very uncomfortable sort of just harvesting from unreliable sources and not reviewing it. But I think that's a good practice, whether you're using ChatGPT or you're just borrowing work from another lawyer. Lawyers make mistakes too. So I guess to answer that question, yes, that is definitely the answer, is you should be thoroughly reading at least the relevant portions of any case law that you're relying on anytime you're doing legal work. Moving to the next question, do you think we will see more regulation of this type of tech through more case law or statute? I think, we talked about the federal judge that's added that as a certification. I think that's sort of a stopgap measure. I think where we're probably most likely to see it is something, at least in the comments to the rules of professional conduct, where I think what we'll see is that the rules committees will say, hey, look, this is an area where lawyers can get themselves into trouble. Let's add some clarification on this so that lawyers kind of know how they're supposed to be using that stuff. We've got a couple of other questions just to kind of get through them real quick.
Well, the last one is a comment and I like it, but let's go ahead and do that next question. So as a law student, or as law students who want to be ethical, knowledgeable, and efficient in practice, we will be dealing with the issue of AI and all of its faults in the future. What is the best piece of advice you can give us to best adapt in the technological world as we are living in today?
I think
Your advice?
I think without getting into too much detail, we're at the point where this technology is something you should trust but verify. Learn to use it, learn to be familiar with it. Don't get left behind as the technology continues to move forward. It's very easy to sort of get into the habit of this is the way we've always done it and sort of miss out on those technological advances. But I think right now we're at the point where it's time to start at least paying attention to them, but recognize their pitfalls, recognize that they can definitely get you into trouble. And if it brings you sources or it brings you information, use that as a stepping stone rather than an end conclusion.
And I think, ultimately, when we're looking at that, we kind of my backup is, when you're looking at Westlaw and you're looking at whether a case is good law or bad, you're doing that verification process every time as a law student, as a lawyer. You're looking at the flags, you're looking at the negative treatment, you're looking at all of that. So in this instance, just keep doing the things that you're supposed to do, because, I don't think that these programs are necessarily going to give us that treatment, the negative treatment and all of that, the way that they currently are in their infancy. Maybe at some point, if Westlaw and Lexis implement these items, then maybe. And then I guess, Jason, do you want to read this comment? I think it's a really great perspective.
Says, I sincerely appreciate the perspective of practicing attorneys concerning their views of artificial intelligence. As a BS MS Electrical Engineering Power Systems, Cyber Physical Systems, and pre-law student with 3.5 decades in electrical critical infrastructure and an understanding of coding and programming, I have zero confidence in these systems. As a person currently studying cyber attacks, I would want these AI systems to be as far away from critical infrastructure as possible. That's just my perspective.
And it's a very valid perspective. I personally am not very fond of using them, and I try to steer away from as much as I can, but at the same time, the world is what it is, and so we need to know what they are and how to use them and how to we need to know what their pitfalls are so that we can kind of go around them. And so that's, even though we don't want them around the infrastructures, we don't want them in our daily lives, we're going to have to deal with them, unfortunately. So, anything else?
Well, thank you both so much for joining us tonight. I know it's a lot to cover in just 1 hour, and we probably only touched on the surface of it. I did include a link to the website in the chat, and also for the new podcast, the YouTube channel in there, that is in the chat. So if you'd like to take those down real quick. Otherwise, we thank you both so very much for joining us tonight and sharing your knowledge.
Thanks
Thank
for
you.
having us.
Hope everyone has a great night.
Good night, everyone.